memo for not press. There memo for not press, my lord. Memo is there with the file, my lord. There are two items
Just
arising.
wait, please wait. 163,
my lord.
Okay. Both the matters disposed of as we know.
Published.
Item 128. I have filed two IAs, my lord. One is for fixing a date of hearing and another for stay of conviction. That stay of conviction means IA has not come. Your lordship may call it. And in that case, the state has also filed the objections.
You want it next week?
Next week, along with this,
which item?
Item 128.
128. What is that IA number?
IA number 1535 has not come. 917 has been listed.
1535 of 2023. All right, Mr. Item number 128. Mr. Deva Prasad Das, Land Council, appearing for the appellant, submits that an interim application has been filed by the appellant for stay of conviction of the impugned judgment, and the same has been registered as IA number 1535 of 2023, and copy of the interim application has been served, and the learning counsel for the vigilance department, and objection has also been received, and the matter may be taken up next week along with IA number 1535 of 2023. This matter we commencing from 24th July 2023 along with IA number 1535 of 2023.
I don't to mention, my lord, one CRLA 763 for bail, my lord, under SC.
Please give
it. Given last week, my lord. Only 5
All right, we'll see that. Give it here.
Tomorrow.
My lord, CRLA number 621 by 2016, my lord. Here, my lord, the appellant has been connected with a vigilance matter and dismissed from service, my lord. The appeal is ready for hearing, my lord.
Which year?
2016.
All right, give it. Paper book has been prepared?
Yes, my lord.
All right, give it. Yeah.
Another memo, madam, my lord. CRLA 164 by 2012. The appeal is also ready for hearing.
All right, give it to see that. Yeah.
Pardon, lordship, one CRLA 780 for 2021. Conviction was 8 years, and in the meantime, Elser has been called for, and Elser is also available.
For bail purpose.
Pardon, my lord, for bail, arising out of criminal
give it.
10 years conviction.
Give it.
Item 268, 262, man, last item. For condonation of delay, can be taken up against can be taken up at 262, last item of the wiki list.
What is this criminal appeal for?
For conviction against.
What is the delay?
Delay is 30 days.
30?
30 days.
Find out that matter. Last matter. Appeal memo. "43 days delay is there. Okay, RI for 10 years. Yes, Mr. Misra, it's a 10 years sentence, so let the delay be condoned. Right. IA number 1553 of 2023. This is an application for condonation of delay. The stamp report has pointed out that there is a delay of 43 days in filing the criminal appeal. Considering the submission made by the learning counsel for the respective parties, and after going through the averments taken in the interim application, and since it's an appeal against conviction in which 10 years substantive sentence has been imposed on the appellant, I'm inclined to condone the delay. Accordingly, delay is condoned IA is disposed of her admit call for the trial court record. Deposition copies of the witnesses be supplied to the Land Council for the state. Interim applications for bail and stay relation of fine be considered after receipt of the trial court record.
Okay.
Supplementary list item number 2.
Please, your lordship, my lords. My lords, here your lordship on the last occasion had directed to seek instruction on the IA which was filed on behalf of the health grounds of the petitioner who is in custody and is a known case of oral cancer, my lords. An instruction was sought from the jail authorities.
Instruction
As
is
regards-
What is the instruction? You have handed it over to me.
My lord, I have just
When? When you have handed over?
just now. I have a copy with me, but that little bit heavy.
No, you have received it today. This paper. It was handed over to you.
No, by phone. Suffering from oral cancer, and it was operated at Harrier Institute of Cancer Institute, and all things are there.
My lords was pleased to grant him interim bail on earlier occasions on the self-same grounds.
When you were granted interim bail earlier?
My lords, earlier, while in IA number 1173 of 2022, while order dated 8/8/2022, your lordship was pleased to grant me interim bail. Then again, my lords, it was extended by order dated 12/9/2022 for a period of 8 weeks, my lords. Then your lordship had also again extended on 14/11/2022 for a period of 10 weeks. My lords, then, my lords, I was granted interim bail on 5/4/2022. 5/4/2023, my lords. And again on 4/5/2023, the interim.
Last time you were granted interim bail in on 8/8/2022.
Again. In IA number
That was for a period of 2 weeks.
Again.
Then on 12/9/2022 for 2 months.
Again.
Which was extended
For
further a period of 10 weeks.
Again.
On 14/11/2022.
Again, 14/11. I'm sorry.
Then you are granted on
5-4.
no 11/4/23 the matter was taken,
Okay.
and you were granted interim bail for 2 months. All right. IA number 1540 of 2023. Where is that application? This interim application has been filed by the appellant for interim bail on the ground that he is suffering from oral cancer, for which he had undergone surgical operation and treatment at Acharya Harihar Post-Graduation Institute of Cancer, Cuttack. So also chemotherapy and follow-up treatment. It is further submitted that the petitioner was earlier granted interim bail on some occasion, and after availing the same, he surrendered at right time, and therefore there is no chance of absconding. The learned counsel for the state was asked to obtain instruction on the averments taken in the interim application. Today, the learned counsel for the state has produced the letter dated 13/7/2023 of the Superintendent Sub-Jail Nimapda, along with the report of the jail medical officer, wherein it is mentioned that the petitioner is complaining of harshness of voice with muffled speech, and there was intermittent bleeding from oral cavity, and his condition is gradually deteriorating. And at present, he is not able to speak properly, and also having difficulty in swallowing the food particle and drinking water. And looking at the current health condition, he needs to be referred for follow-up treatment to Cancer Hospital at Cuttack as soon as possible for betterment of his health. The report furnished by the learned counsel for the state is taken on record. The petitioner was granted, it appears from the case record that the petitioner was granted interim bail by order dated 8/8/2022 in IA number 1173 of 2022 for a period of 2 weeks, and further granted interim bail for a period of 2 months by order dated 12/9/2022 in IA number 1151 of 2022, which was extended for a further period of 10 weeks by order dated 14/11/2022 in IA number 1806 of 2022. He was then granted interim bail for a period of 2 months by the order dated 11/4/2023 in IN number 1084 of 2022. And nothing has been pointed out that he has misutilized his liberty in any manner. And it seems that the petitioner, after availing the interim bail period, surrendered at right time. Considering the submission made by the land counsel for the respective parties, the health condition report obtained by the land counsel for the state from the jail superintendent, the conduct of the petitioner in complying with the previous interim bail orders, I'm inclined to grant him interim bail for a period of 2 months from the date of release. The petitioner shall immediately surrender before the land and court below on expiry of the aforesaid 2 months period. IA is disposed of. This matter, give a date, he will file the surrender certificate.
Let's may I pray for an urgent copy in
Yes.
course of the day.
Yes.
Grateful, my lords.
Item number 3.
Lord, please, your lordship. In item number 3, my lords, inadvertently I had missed out to file the copy of the deposition to my learned senior. I have handed over the copy of the deposition by my lord's last order today. And he has
Today you have-
also.
You have received it.
Just now I received.
All right.
I pray before your lordship that I have filed only 4 decisions. Besides, in my objection, I referred to 11 decisions. And this decision, latest decision of the Supreme Court, I want to bring it to the notice of your lordship. The
No,
only one paragraph.
Mr. He just wants it to be taken up perhaps next week. You have received the deposition copy today. So you go through it, we'll take up next week.
No, my submission before your lordship is one line.
Yeah.
So the Honorable Apex Court has held the appellate court should not reappreciate the evidence at the stage of section 389 CRPC and try to pick up few lacunas or loopholes here and or there in the case of prosecution. Such would not be correct approach. All these things or all these aspects will have to be looked into at the time of final hearing of the appeals filed by the convicts. I want to bring it to the notice of your lordship.
If the memo of citation to the land.
I have already given. And your lordship, I want to satisfy your lordship by showing only one paragraph.
No, let it be. It will be hard next week.
No, 1 week after, let it be taken up 1 week after May.
All right, then to next
As
week
your
is
lordship-
25th. Then it will be taken up on 1st of August.
Yes.
My lords.
All right. The Mr. Sudipto Pandal and counsel appearing for the appellant submitted that today he has handed over the copy of the deposition of the witnesses examined in the trial court to the Land and Standing Counsel for the Vigilance Department in court. Stop. Mr. Sanjay Kumar Das, Land and Standing Counsel, has filed certain decisions with a memo of citations which are taken on record. Copy of the same has been furnished to Mr. Panda. On consensus of both the parties, list this matter on 1st August 2023 for orders. Yes.
My lords, grateful, deeply obliged.
Weekly list item number 38. Item number 39.
May I plead, Your Lordship?
What is this defect number 6B?
My lord, I have solved the copy. It is defect shows that government copy has not been solved, but as per Lordship direction, I have solved.
You have received the case
Yes.
diary?
No, case diary is available in another file. PLA 4134.
Well, fact is that BLAPL was earlier filed. Bail petition has been earlier filed mistakenly, so it has been converted to the present appeal.
No, it is available in the AG office. It's not that. So it will be taken up next week. The Learned Council for the state submits that the case diary is available in the BLAPL file, which was earlier filed and converted to CRLA, and the matter may be taken up next week.
My lord, charge sheet has also been filed in the said case. I have also solved the copy to
Okay. All right. Next case.
deploy.
Item number 40.
May I please, Lordship? What is the case of 302 and other offences?
What is the
And the
defect?
Lordship.
Defect number 9.
Lordship may verify the same admitted case issue notice to the
Okay.
opposite parties.
So what happened to the notice? You have appeared.
On instruction, I will appear in this case, my lord.
On the instant of the informal Lordship, the earlier occasion, the matter was disposed of by the Supreme Court.
Different.
Lordship has granted bail to the other two clients in connected to the same case, Lordship.
You have received the case diary, Mr.
No, CD is not available.
Okay,
It
you
might
file
be-
your.
Might be available the another case, Lordship.
You hand over the
Yes.
Learned Council for the state seeks some time to produce the case diary. Mr. Sharat Kumar Jena, Land Council, submits that he has instruction to appear for the informant and he will file the wakalatnama during course of this week. Land Council for the appellant handed over the copies of the bail orders of co-accused persons to the Land Council for the state in court. Let the Land Council for the state obtain the case diary and also verify the bail orders relating to claim of verity. Matter be listed in the week commencing from 24th July 2023, indicating the name of Mr. Sat Kumar Jena in the cause list. Yes.
Item number 41.
Yes, Mr. Dwivedi. The bail application.
Bail application under the SC statement.
What about the notice, Mr. Tripathi?
My lord, I am
On
You are
3
happy?
days.
Where is your wakalatnama? Mr. Preeti Shagar Mahananda and his associates have filed power for the informant along with objection to the bail application is taken on record. Have you received the copy of the?
Yes, ma'am.
Copy of the objection has been received by the Land Council for the appellant. You have also received
Yes, ma'am.
as well as Land Council for the state. Okay.
Appellant is in custody since 3/11/2022, ma'am. The charge sheet submitted under section 302/201 of the Indian Penal Code, read with section 3 within bracketed 2 within bracket V of the SC statement. The
What is the name of the
name of the
deceased?
deceased is Janaki Mohanand.
Janaki?
Mohanand. The prosecution case is on
What is the date of occurrence?
date of occurrence is 31/10/2022. FIR was lodged on the next day, 1/11/2022. My lord.
Who is the informant?
Informant is Padmanabha Mohananda, who is the son of the deceased.
Is any eyewitness to
No,
the
my lord.
occurrence?
Only circumstances is the confession of the present accused person before the police and recorded under section 27 of the Indian Evidence Act.
What was recovered at your
Recovered
instance?
at the spot one bamboo stick and one sheath, da gote.
Sickle.
Yes. The FIR lodged against unknown person.
How many days after occurrence these two things were seized at your instance?
Arrested on 3/11/2022. That was seized on 3/11/2022.
Okay, 3/11.
After my lord 4 days.
What else is there?
My lord.
What else is there apart from
nothing. Apart from that, one statement is there that there was a previous dispute between them regarding the flows of water because the land of the appellant is situated below the land of the appellant, below the land of the
civil dispute?
Civil dispute, and they suspect that the appellant might have committed murder of the deceased. One statement I may be allowed to read. That is Bhajaraj Mohanand.
Regarding that previous dispute?
Yes.
What is the name of the witness?
Bhajaraj Mohananda.
Bhajaraj.
Relevant parties. ଗତ 31/10/2022 ସକାଳ 10ଟା ସମୟରେ ମୋର ଭାଉଜ ଜାନକୀ ମହାନନ୍ଦ ତାଙ୍କ କ୍ଷେତକୁ ଯାଇଥିଲେ। ସନ୍ଧ୍ୟା 5ଟା ସୁଦ୍ଧା ନ ଫେରିବାରୁ ମୋତେ ମୋର ଝିଆରୀ କୌଶଲ୍ୟା ମହାନନ୍ଦ କହିବାରୁ ଆମ ଘର ଲୋକ ଯଥା ସୁରଜ ମହାନନ୍ଦ ସୁଆଂଶୋ କ୍ଷେତକୁ ଗଲେ। ଯାଇ ଦେଖିଲେ ମୋର ଭାଉଜର ଚପଲ, ମୋବାଇଲ ଓ ଗୁଡାକୁ ଡବା ଜମିରେ ଆଡ଼ିରେ ପଡିଛି, କିନ୍ତୁ ମୋ ଭାଉଜ ଦେଖାଯାଉ ନଥାନ୍ତି। ସେମାନେ ଆଖପାଖ ଅଞ୍ଚଳ ଖୋଜାଖୋଜି କଲେ, ନ ପାଇବାରୁ ଡାକିଲେ। କ୍ଷେତ ଭିତରୁ ମୋ ଭାଉଜର ଗଁ ଗଁ ଶବ୍ଦ ଶୁଣି ଜମି ଭିତରକୁ ଯାଇ ଦେଖିଲେ ତାର କପାଳରେ କ୍ଷତ ଚିହ୍ନ ଅଛି ଓ ସେ ଚେତା ହରାଇ ପଡିଛି। ତାକୁ ସେ ସଙ୍ଗେ ସଙ୍ଗେ ଘରକୁ ଆଣି କପଡ଼ା ଦେଖାଇ ମୁହଁ ବନ୍ଦ ଡାକ୍ତରଖାନାକୁ ଆଣିଲେ। ଡାକ୍ତରଖାନା ତାଙ୍କୁ ମୃତ ଘୋଷଣା କଲେ। ଆଜି ଆପଣ ଆସି ଭାଉଜର ପଞ୍ଚନାମ କଲେ ଓ ଆମକୁ ପଢି ଶୁଣାଇଲେ। ଆମେ ଶୁଣି ସାରିଲା ପରେ ପଞ୍ଚନାମ ଦସ୍ତଖତ କଲୁ। ମୋର ସନ୍ଦେହ ଆମ ଗାଁର ପୁଷ୍କର ଗହିର ତାଙ୍କୁ ମାରିଥିବ, କାରଣ ପୁଷ୍କରର ଜମି ତଳେ ଓ ଆମ ଭାଉଜର ଜମି ଉପରେ ପାଣି ପାଇଁ ପ୍ରାୟ ସବୁବେଳେ ଗଣ୍ଡଗୋଳ ଲାଗେ।
What is the cause of death as per
Cause
PM?
of death as per the PM is due to head injuries and its complication thereof.
Yes, Mr. Tripathi.
There is a last scene theory.
Who has stated that?
One Ukila Gahiri. 164 statement of that. গত সোমবার
Kilo?
উকিল গহিরি
GHIRI.
আর খালিয়ার
हाँ
খালিয়ার আইনে
अच्छा गहीर अच्छा
গহির
yes
ম্যারিড গত সোমবার মু ଆଉ ମୋ ସ୍ତ୍ରୀ ଧାନ
when the statement was recorded
311 164 statement.
That means on the FIR within 2 days it was recorded.
Yes,
3/11/2022. Yes, what he has stated?
ଗତ ସୋମବାର ମୁଁ ଆଉ ମୋ ସ୍ତ୍ରୀ ଧାନ କାଟୁଥିଲୁ ଦିନ 12 ବଜେ। ସେହି ସମୟରେ ଜାନକୀ ମହାନନ୍ଦ ଆଉ ପୁଷ୍କର ଗହିର ତାଙ୍କ କ୍ଷେତରେ ଝଗଡା ଲାଗୁଥିଲେ। ପୁଷ୍କର ଗୋଟେ ଠେଙ୍ଗା ଆଉ ଗୋଟେ ଦା ଧରିଥିଲା। ତାଙ୍କ ଝଗଡା ଦେଖି ଆମେ ଦୁଇ ଜଣ ସେଠାରୁ ଭାଗି ପଳେଇ ଆସିଲୁ।
What is the time they saw it?
12 बजे।
Yes, what is your submission?
My lord, as per the last scene theory, The present appellant committed the murder of the deceased.
No, last scene is there. So that is last scene was one circumstance. One circumstance is previous dispute is there. Then about that recovery of that bamboo stick and sickle. These are the three materials.
My lord.
Any criminal antecedent?
That has not come.
Your case diary doesn't indicate.
Does not reveal.
All right, heard the learned counsel for the appellant, learned counsel for the state, and learned counsel for the informant. The learned counsel for the appellant submit that the appellant is in judicial custody since 3/11/2022. And he has been charge sheeted under section 302(201) of the Indian Penal Code, section 32B of the SC/ST POA Act. The occurrence in question took place on 31/10/2022, and the first information report was lodged by one Padmanabh Mahananda with the son of the deceased Janaki Mahananda on 1/11/2022. At Sanitala Police Station. It is further submitted that there are no eyewitnesses to the occurrence, and the case is based on circumstantial evidence. And it appears from the statement of one Bhajaraj Mahananda, who is the brother-in-law of the deceased, that there was civil dispute between the parties, and it is suspected that for such dispute, the appellant might have committed murder of the deceased. It is further submitted that it is the prosecution case that at the instance of the appellant, one bamboo stick and a sickle was recovered, based on the statement of the appellant recorded under section 27 of the Evidence Act. And counsel argued that in view of the available material on record and the period of detention of the petitioner in judicial custody, the bail application may be favorably considered. Learned counsel for the state, on the other hand, opposed the prayer for bail and submitted that one Ukil Gohir has given a 164 CRPC statement on 3/11/2022, in which he has stated about the appellant and the deceased were present on the land around noon time, and they were quarreling. And the appellant was holding one bamboo stick and a sickle. It is further submitted that the post-mortem report indicates that the cause of death was on account of head injury and complication thereof. However, he submits that the case diary doesn't reveal any criminal antecedent against the appellant. The learned counsel for the informant opposed the prayer for bail and submitted that even though there are no direct evidence against the petitioner, but the clinching circumstantial evidence is there, and therefore he should not be released on bail. Considering the submission made by the learned counsel for the respective parties, nature of accusation against the petitioner, absence of any direct evidence, nature of circumstantial evidence on record, period of detention of the petitioner in judicial custody, I am inclined to release the petitioner on bail allowed.
Item number 42.
Lord, item number, my Lord, may I please lordship.
Yes, Mr. Das.
Item number 42 and 47 both are arising out of one PS case number, my Lord.
You have received the case diary, Mr. Tripathi.
No case. There is a notice also sent, but not confirmation letter received.
42 and connected is 47.
Yes, my Lord.
You have already sent the notice
Yes,
to the.
This has been sent since 2 days, man.
But you have received the case diary.
No, my Lord.
Which police station it is?
Swadev Kunta.
Huh?
Baleswar, your lordship, that is Swadev Kunta police station, my Lord.
Baleswar Sadar.
In 47 also no cities. Right, get it will take up on 24 along with the instruction about the receipt of notice. Okay.
So also criminal antecedent, lordship, direct.
Criminal antecedent is there. Okay. The CRLA number 537 of 2023, same order in also in CRLA 575 of 2023. The Land Council for the state submitted that he has not received the case diary and also instruction about the sufficiency of service of notice on the informant and criminal antecedent, and the matter may be taken up next week. As prayed for, list this matter on 24th July 2023. Same order in item number 47.
Item number 43.
Yes, may I please, lordship, my Lord. Present petition is behind bar, my Lord. Since
It's also a seized matter.
Yes, my Lord.
Notice sufficient?
Yes, my Lord. 26/6/23.
And you have received the case diary?
Yes.
Okay.
Yes, may I please, lordship, my Lord.
Just a minute.
Present petitioner, my Lord.
Yes, custody.
And inside custody 9/3/2023, my Lord.
Charge sheet submitted.
Charge sheet submitted under section 4(2) of Poison Act, my Lord. So far that against present petition is concerned. So far that principal accused is concerned, my Lord. Charge sheet has been submitted under section 302, 452.
There are two accused persons in
Yes,
this
my
case.
Lord. So far the case is that, my Lord.
No, there are two
No,
accused persons.
There are more than one.
More than.
5 accused persons.
So, what this, please show that off. Have you got that book 4-2?
That is a punishment may extend to 1
No,
year.
I just want to see.
I have also indicated.
You should have handed over the book to him.
Paragraph E I have indicated. Punishment may extend to 1 year.
That may not be there. That
Dealing with the substance without any license.
Yeah, okay, you find it out from the EBC. Close this and what is that EBC?
Yes.
Oh, login.
I have supplied a certified copy of the charge sheet.
No, I just want to see that what is that
Punishment one.
Provision, what it says. Search me. The act is called Poison Act. No, there is no book is here. Leave it, leave it. You come to the Google. Of which year?
1990.
1990.
1919
But there is thereafter there is another act 1972 also. You find out that 72.
Sir, should indicate the forerunner of a Poison Act, 1990.
No, it's 1919 you say. Okay, they let us see that. 1919. No, 19. No, it's not. Okay. Code it reads like this, Mr. Das.
Yes, ma'am.
And Mr. Tripathi.
Yes, ma'am.
This Poison Act 1999. It says like this, Section 4, he has been charge sheeted under Section 4. 4 says about power to regulate possession of any poison in certain cases. The state government may regulate the possession of any specified poison in any local area in which the use of such poison for the purpose of committing murder or mischief by poisoning cattle appears to be of such frequent occurrence as to render restriction on the possession thereof desirable. In making number 2, it says, in making any rule under subsection 1, the state government may direct that any breach thereof shall be punishable with imprisonment for a term which may extend to 1 year, or with fine which may extend to 1,000 rupees, or with both, together with confiscation of the poison in respect of which the breach has been committed, and of the vessels, package, or covering in which the same is found. So this is what Section 4 says. The punishment is 1 year. So
Statement of one witness, S.K.SAHOO, speaks that present petitioner has got a shop and a prime accused Chandana Rana and his employees purchased acid from his shop. Thereafter, Chandana Rana threw that acid towards the victim. Victim succumbed to the injuries. This is the case, ma'am.
what do you say, Mr.? If it is 1 year only, then it becomes bailable offense.
Bailable offense, but this person has sold the acid. Acid.
Who?
This person, this petitioner.
No, he has stated that only he was charge sheeted under Section 4.
No,
4(2).
he only sold the acid to the principal.
Right, that is
yes, that is the allegation.
He has not done any other.
No.
So please say so. The CRPC criminal
schedule, as per schedule, it would be available.
Please give me the charge sheet copy.
I folded
He only charge sheeted on the 4-2 of Poison Act.
That what he's saying.
Yes.
Sure. Prabhat Sahu. It is right. Bhaiya alias Prabhat Sahu, son of Bhaskar Sahu, is liable under Section 4(2) of the Poison Act 1999. Main accused is Chandan Rana.
Chandan.
Are the learned counsel for the apparent learned counsel for the state. The learned counsel for the state submitted that notice on the informant has been made sufficient. None appears for the informant. Learned counsel submitted that the appellant is in judicial custody since 9/3/2023, and he has been charge sheeted under Section 4(2) of the Poisons Act, 1999. And the main allegation is against one Chandan Rana alias Tubulu, who has been charge sheeted under Section inter alia for commission of offence under Section 302 of the Indian Penal Code. The only material available against the petitioner is that the main accused purchased one acid bottle,
Two
acid bottles from the shop of the appellant, which was utilized by the main accused to kill the deceased. Learned counsel for the appellant further submitted that the punishment prescribed for the offence under Section 4(2) is 1 year, and as per the second schedule to the CRPC, such offence is bailable in nature, and therefore the bail application of the petitioner may be favorably considered. Learned counsel for the state has produced the case diary and doesn't dispute about submission of charge sheet against the appellant under Section 4(2) of the Poisons Act 1999, and that the main allegation is against Chandan Rana alias Tublu. Has this person got any criminal antecedent, Mr. Tripathi?
No, Miller.
The learned counsel for the state further submits that the case diary doesn't reveal any criminal antecedent against the appellant. Considering the submission made by the learned counsel for the respective parties, the period of detention of the appellant in judicial custody, the offense under which he has been charge sheeted, and the punishment prescribed for such offense, and absence of any criminal antecedent against him, I am inclined to release the appellant on bail allowed. Neeraj to the
Item number 44.
44. There are some defects, madam. You have removed the defect. 5D is the State Council copy. You have received the copy.
Yes, my lord.
And case diary is available.
No, my lord. Yes, there is.
It's a SC/ST matter, bail matter. Notice sufficient.
Yes, my lord.
Where from it will come? The case diary? Which police station?
Saranpur. Saranpur.
Saranpur.
Nayagaon.
What is the offense here?
Offense is under section 341, 323, 294, 302, 307,
302 is there.
Yes, ma'am.
So get the case diary. We'll take up this matter next week.
The defects.
The
7,
other
9,
defects
10.
are
7, 9, 10. There are so many defects.
oh, these are minor defects.
Yes.
This are seen. The learned counsel for the state submitted the notice on the informant is sufficient, non-obvious for the informant. However, he submits that he is yet to receive the case diary along with instruction about the criminal antecedent. Place this matter in the week commencing from 24th of July 2023. Yes.
Okay.
Item number 45.
May please your lordship. While in this case, the appellant has been convicted under section 307 IPC and sentenced to
You have supplied the position copies?
my lord, my lord.
Mr. Tripathi, you have received it?
Yes, my lord.
So, come to the relevant operative part of the judgment. Let us see what is the sentence imposed and conviction and what is the sentence imposed. 7 years fine of rupees 5,000 in default, SI for 6 months under 307. So, who is the injured in this case?
The PW8. PW8, my lord.
And doctor is?
Doctor has not been examined, my lord.
Then what is the medical report?
Report is exhibit 3/3.
Who has proved that?
My lord, the prosecution, my lord.
No,
The IO.
Why the doctor could not be examined?
He has not been charge sheeted as a witness in the charge sheet, my lord.
No, but
nor prosecution file and petition.
That should have been done. So you were on bail during trial?
My lord.
What is the weapon of us?
The injured, all the witnesses have stated that the present appellant assaulted the injured by means of a bhujali.
Bhujali.
But the injury report shows there is no cut injury.
Let us see that LCR. LCR has not received. So please, have you got that copy of that exhibit?
I have exhibit. Yes, I have filed, my lord. Last page. I have filed the deposition copies, my lord.
No, not deposition copy. I'm
exhibit. Yes, my lord. All exhibit 3/3 also, my lord.
Okay.
Injury report, my lord. Yes. Last page.
Okay, 3/3. Okay, as it appears, there are 2 lacerated wounds.
My lord.
One is on the left eyebrow, the other is on the right palm.
My lord. And all the injuries are simple in nature.
Where has been mentioned? Okay, simple.
Last
simple.
line.
All right. And the witness has stated that it was the weapon was bhujali.
Yes,
the injured.
But that is not in their 161 statement.
Okay. Heard the learned counsel for the petitioner, learned counsel for the state. This is IN number 1255 of 2023 is an application for bail. Submit that the petitioner was on bail during trial and he has never misutilized his liberty. It is submitted that though the injured PW8 stated that he was assaulted by means of a bhujali, but the injury report exhibit 3/3 indicates that he has sustained 2 lacerated wounds and both the injuries are simple in nature. The doctor who prepared exhibit 3/3 was not a charge sheet witness and he has not been examined during trial. It is submitted that there is no chance of early hearing of the appeal and balance of convenience is in his favor. Therefore, the bail application may be favorably considered. Learned counsel for the state declared the evidence of PW8, so also the injury report exhibit 3/3. Considering the submission made by the learned counsel for the respective parties, the nature of evidence adduced by the prosecution during trial, the fact that the petitioner was on bail during trial and there is no material that he has misutilized his liberty in any manner, absence of any chance of early hearing of the appeal in the near future, I'm inclined to release the petitioner on bail, stay realization of fine.
Obligement.
Item number 48.
I am appealing for the
47 is
informant matter.
connected to 42, so it's over. Yes, madam.
I am appealing for the informant matter.
Informant. So Om Prakash Sharan is not okay. You are there. You have received the case diary,
Yes.
Mr. Sasmita Nanda, Land Council, files Wakalatnama for this man is the informant.
Yes, ma'am.
Informant Amin Pradhan, which is taken on record. Okay, Mr. Saran, argue the matter. Since when you are in custody?
Since I am in custody since 11/10/22, my lord.
11/10/2022.
Aye.
What are the offences under which charge sheet submitted?
Here to IPC, related with section 33
Please tell once again. Once again. Tell the offences.
to IPC. 302 IPC.
What are the
302, my lord. 302 IPC.
302 IPC.
302.
Yes.
302, then
CSCST Act. All.
360.
We of the SC Preventive Atrocity Act.
Okay. There is 302 and 360 Act. Mr. Tripathi?
Yes, my lord.
Okay. What is the
32B and 31R.
31R.
Yes.
Okay. What is the name of the deceased?
Gangadhara Pradhan.
Gangadhar Pradhan.
Date of occurrence?
9/10/2022.
At 12 noon.
FIR lost?
10/10/2022.
With the informant in the case?
Amin Pradhan.
No. How he is related to the
Brother, elder brother.
informant is the elder brother of the deceased. Any eyewitness to the occurrence?
Yes.
Who is eyewitness?
Reena Pradhan.
Who is she?
She is co-villager.
Co-villager. Okay. What she has stated?
Married.
Please read.
9/10/22 ତାରିଖ ଦିନ ଛେଳି ଚରାଇବାକୁ ଯାଇଥିଲି। ମୋ ଠାରୁ କିଛି ଦୂରରେ କୁନି ଦେଉରୀ ମଧ୍ୟ ଛେଳି ଚରାଇବାକୁ ଆସିଥିଲା। ମୁଁ କୋଷାଗଡ଼ ଛକ ପୋଲ ପାଖରେ ଛେଳି ଚରାଉଥିବା ବେଳେ କୁଷାଗଡ଼ ଗେଡାର ସହଦେବ ଦେହୁରୀ, ପିତା ସୌରୀ ଦେହୁରୀ ଓ ସୀମନ୍ତପୁର ଗ୍ରାମର ଗଙ୍ଗାଧର ପ୍ରଧାନ ରାସ୍ତା ଉପରେ ପାଟିତୁଣ୍ଡ ଓ ଯୁକ୍ତିତର୍କ ହଉଥିଲେ। ସେତେବେଳେ ପ୍ରାୟ ଦିନ ଦ୍ୱିପହର ହୋଇଥାଏ। ଟିକିଏ ଟିକିଏ ମେଘ ପଡୁଥିଲା। ଏହି ସମୟରେ ଶେଷଦେବ ରାସ୍ତା ପାଖରେ ଲଗା ହୋଇଥିବା ଗଛ ଚାରିପଟ ବାଡରୁ ଗୋଟିଏ କାଠ ବାଡି ଓପାଡ଼ି ଆଣି ହଠାତ୍ ଗଙ୍ଗାଧର ପ୍ରଧାନକୁ ପ୍ରହାର ପକେଇଲା। ତାପରେ ଗଙ୍ଗାଧର ରାସ୍ତା ଉପରେ କଚାଡି ହୋଇ ପଡ଼ିଲା। ସେତେବେଳେ ଆଖପାଖରେ କେହି ଲୋକ ନଥିଲେ। ତାପରେ କିଛି ସମୟ ପରେ ଗଙ୍ଗାଧର ପ୍ରଧାନର ଲୋକ ତା ଭାଇ ଆସିଲେ, ତଳେ ପଡିଥିବା ଜାଗାରୁ ତାକୁ ଉଠେଇକି ନେଲେ। ପରେ ଜାଣିଲି ଶେଷଦେବ ଦେହୁରୀ ମାଡରେ ଗଙ୍ଗାଧର ମରିଯାଇଛି।
So it appears that there was some quarrel between the two.
Yes.
So he pulled a stick from the fence on the side of the road and dealt one blow.
One to coach.
No. What is how many injuries are there?
One injury, that is a brain injury, Lordship.
External injury is one.
One. And that is
Head
brain.
and brain injury as
Pass on the that PM report.
my lord.
Pass on. What about the criminal antecedent? Yes, Mr. Saran, any criminal antecedent?
Nothing. Don't see it.
As the case regard, my lord,
Yeah.
the brother of the deceased, one of the brother of the deceased is a paralysis patient. This petitioner went to his house frequently and get relationship with his wife, that paralysis patient's wife. Because of that, there was a quarrel. And taking revenge in this way, that while he is coming out from his paddy field, he assaulted him by.
All right. Heard the Learned Counsel for the Appellant, Learned Counsel for the State, Learned Counsel for the Informant. Mr. Om Prakash Saran, Learned Counsel appearing virtual court. It's from Dhenkanal you are appearing, Mr. Okay, from virtual court Dhenkanal. Submit that the appellant is in judicial custody since 11/10/2022. And he has been charge sheeted under section 302 IPC, section 31R, oblique 32B of the SC/ST PO Act. The occurrence in question took place on 9/10/2022, around 12 noon. And FIR was lodged on 10/10/2022 by one Amin Pradhan, who is the elder brother of the deceased Gangadhar Pradhan. And it is the prosecution case that during sudden quarrel between the appellant and the deceased, the appellant pulled a stick from the fence by the side of the road and dealt a single blow on the head of the deceased, which resulted in his death. It is argued that in view of the background of the case and the surrounding circumstances under which the offense alleged to have been committed may not be a case under section 302 IPC. Therefore, the bail application may be favorably considered. And counsel for the state, on the other hand, opposed the prayer for bail and played the statement of one eyewitness, namely Reena Pradhan, who is a co-villager, and stated about the stick blow given by the appellant to the deceased Gangadhar Pradhan. He also placed the post-mortem report, which indicates that the deceased has sustained an injury on the scalp, and the cause of death has been opined to be brain injury, which resulted in shock and hemorrhage. The learned counsel for the informant opposed the prayer for bail and submitted that the brother of the deceased was a paralysis patient, and the appellant was visiting his house frequently and was having extramarital relationship with the wife of the said brother of the deceased, which caused dissension between the appellant and the deceased. Considering the submission made by the learned counsel for the respective parties, the nature of accusation against the petitioner, the surrounding circumstances under which the offense allegedly committed, the nature of injury sustained, and the finding of the postmortem report and the period of detention of the petitioner in judicial custody, I am inclined to release the petitioner on bail allowed.
Obliged, my lord.
Item number 49.
Mr. Chiranjeev Vidyabhushan.
Compliance to lordship last direction.
Please use the mic properly. I am not able to hear you. On ही नहीं कहीं.
My lords, in compliance to your lordship's last direction, I have filed an IA for change of nomenclature, my lords. From CRLA to FAO.
Yes, Mr. Miller. IA number so and so. This is an application for change of nomenclature from CRLA to FAO. Mr. Patra, who has received the copy of the interim application, has no objection to such prayer. Prayer is allowed. The registry shall re-register the case as FAO and the matter be placed before the assigned bench. IA is disposed of. Yes.
You need one extra copy of the FAO may be served on.
Okay, the extra copy of the FAO shall be served on the land council for the state by the land council for the appellant. IA disposed of.
Obliged, your lordship. Item number 24.
Mr. Satyanarayan Misra is not there. What is this criminal appeal, Mr. Das?
Bail Miller 302 3 SCST.
He was not there yesterday.
No, not there.
Notice sufficient.
Miller.
All right, none appears for the appellant on repeated call. Land counsel for the state submitted that he has received the case diary.
Miller.
And notice on the informant is made sufficient. List this matter in the week commencing from 7th August 2023.
Item number 25. Item number 52.
52, my lord. Bail application under section 3 SCST and 307.
Notice sufficient?
Yes, my lord. Notice.
When?
My lord, that has been 26th. My lord, 28th June, my lord.
Okay. So you have received the case diary?
Yes, my lord.
What is the date of custody, Mr. Das?
Here, my lord, 12/3/2023.
Charge sheet under section?
Charge sheet filed on 7/7.
What are the offenses?
Offenses 341.
Yes.
143, 147.
No. 341, 147. 148.
148.
Then?
323.
320. Oh,
326.
Yes.
307.
Yeah.
294. 506. 120B. 149 of IPC. 2527 Arms Act. 3 SCST. 31 is 31R.
31R.
My lord. 32V.
32V.
Of SCST Act.
Who is the injured here?
Jagannath Karna. The lordship has granted bail.
Jagannath Parna.
Karna.
Karna.
Your lordship has granted bail in criminal appeal number 465, 486 and 487. The similar footing like petitioner. Because you are only standing there, a member of
Injured has not attributed any assault on the.
No, not against the.
You are just standing there.
My lord. Others stated, injured statement doesn't stated anything about the present petition. Injured and brother lordship has categorically mentioned. Other witnesses have stated, my lord, he was standing along with the others, other accused persons.
And he has been discharged also from the hospital.
Yes, that is
all right. Heard the learned counsel for the appellant, learned counsel for the state. Considering the submission made by the learned counsel for the appellant that the appellant notice sufficient non-appears kar dein. Custody since 12/3/2023, charge sheeted under section so and so. And injured Jagannath Karna has already been discharged from the hospital. He is quite well and hearty. And no specific overt has been attributed against the appellant. And similarly situated co-accused persons have been released on bail in CRL number so and so, copies of which filed and taken on record. And after hearing the learned counsel for the state, I'm inclined to release the appellant on bail allowed. Next.
Item number 53.
May I please proceed? This is a case bail under section 3 SCST Act, my lord, for that. The petition is custody since 7/11/2022, my lord.
You have received the case diary?
My lord.
7/11.
Yes, my lord.
20.
Offense under section 302/201.
7/11/2022. Charge sheet under section
302/201, 34 IPC, read with the 32V of the SCST Act.
Name of the deceased.
Name of the deceased, my lord. Manoj Gochar. Manoj Gochar.
Date of occurrence.
My lord, what happened in this case? Just because of a missing report filed on 15/10/2022, stating that his son missed on 13/10/2022. Thereafter, in 1/11/2022, the informant reported before the police station he saw in a riverbank sand the one skull and shirt, one piece of the shirt. Basing upon that, FIR registered on 2/11/2022, and absolutely no eyewitness, circumstantial evidence, and for the present petitioner, my lord, absolutely no, only confessional statement of the co-accused. He has been added and accused and arrested, and no leading to discovery from the present accused, my lord. And the similar footing, those are some allegations. Your lordship granted bail in CRL number
388 of 2023 on 8/5/2023, my lord.
Is it correct, Mr. Mahapatra?
My lord.
Confessional statement of co-accused is the only material.
No, my lord, the author leading to discovery and other.
Leading, no, he said nothing against him.
From the my possession.
Another witness.
Right. At his instance, nothing has been recovered. It is at the instance of co-accused. What is the actual correct state of affair? Who has led the police party?
My lord, Khirot, my lord, the petitioner.
Manakuru?
No, I have
What was recovered?
from the my possession, nothing has
Wait.
been
He's placing the document.
ମନୋଜର ମୋଟରସାଇକେଲ ଚାବିଠୁ ଗାଡିରେ ପକାଇଥିବା ପାଖ ଗୁଦାମରେ ମୁଁ ଲୁଚେଇ ରଖିଛି ସେଇ ସ୍ଥାନ
କଣଟା ଲୁଚେଇ ରଖିଛି?
ମୁଁ ମାନେ
କଣଟା ଲୁଚେଇ ରଖିଛି?
ଗାଡିର ଚାବି।
ଗାଡିର ଚାବି ସେଗୁଡାକ ଦେଲା।
ମନୋଜର ଚାବି।
Manoj is the deceased.
My lord.
So key of the motorcycle of the deceased.
My lord.
Yes, what is your submission?
My lord, the statement of my lord Vishwaranjan Hemram is the RIF local Tahsil, my lord, before whom he has confessed the statement, my lords, and he is also the leading witness to the leading to discovery, my lord.
Vishwaranjan Hemram.
Vishwaranjan Hemram, RIF Mandari, my lords, is the official witness.
Oh, he was present when that leading to discovery took place.
My lord.
So in presence of police, the statement has been made.
My lord,
confessional statement made, which was recorded, reduced to writing. On that basis, this key of the motorcycle was recovered.
In presence of my lord Vishwaranjan Hemram, the official witness, my lords, along with
and who have been released on bail, Mr. Mahapatra?
Mr. Punni alias Savita Parida.
So where is the bail order? That's a lady.
I have annexed, that is page 11, my lord.
It's a lady.
My lord, because of lady Millers and Millers, I have filed
11, 12 and 13.
Wait.
I have filed my lord Bhakalanam on behalf of the informant Millers, but unfortunately my
now you are getting opportunity to have your say.
My lords.
So
what my lord friend is
no, it's all right. At that point of time, you filed Wakalatnama. Your name was not listed. All these things. Bail has been granted.
Because of lady Millers. My lord has considered.
No, not that. That's so many things have recorded. No, only lady. Submission record ହେଇଛି. Polite heard the land council for the appellant land council for the state land council for the informant. The land and council for the appellant submitted that the appellant is in judicial custody since 7/11/2022 and he has been charge sheeted under section 302-201-34 of the Indian Penal Code, section 32B of the SC/ST PO Act. It is submitted that the deceased Manoj Gushayat was found missing on 13/10/2022 and missing report was lodged in the police station on the very day. And
15/10
on 15/10/2022 and the FIR was lodged on 2/11/2022 and there are no eyewitnesses to the occurrence. Case is based on circumstantial evidence and there is no clinching circumstance available on record against the petitioner and one of the co-accused, namely Kunni alias Sabita Parida, has been released on bail by this court in CRL number 388 of 2023 as per order dated 8/5/23 and therefore the bail application of the petitioner may be favorably considered. Land counsel for the state, while not disputing that the case is based on circumstantial evidence, submitted that at the instance of the petitioner, basing on his statement recorded under section 27 of the Evidence Act, the key of motorcycle of the deceased Manoj Gushayat was recovered. The land counsel for the informant also opposed the prayer for bail and praised the statement of RI Vishwaranjan Hemram, which a witness to the leading to discovery. considering the submission made by the land counsel for the respective parties, the nature of accusation against the petitioner, absence of any direct evidence, nature of circumstantial evidence on record, period of detention of the petitioner in judicial custody, I am inclined to release the petitioner on bail allowed.
Item number 54. '57.
May I please, Your Lordship?
Press matter, Mr. Nayak.
SC/ST and 530.
Press matter.
No, my lord. Notice any issued, my lord.
Notice has already
Notice served, my lord.
served.
My lord.
Okay.
Already custody.
When that was served?
That was served, my lord.
What is the date of custody, Mr. Nayak?
Custody since the 20th April 2023, my lord.
20
April 2023, my lord.
20
April.
April 2023. Charge sheet submitted.
No knowledge.
What is the offenses?
307, 3SC.
307.
Yes.
3SC.
Already injury already discharged from the hospital.
Charge sheet submitted. Charge sheet has been submitted on section 294, 341, 323, 324.
326.
No, 323, my lord. 323, 324, 307.
Yes.
34 of IPC, 31 and 32B of AC and ST Act.
Name of the injured?
Injured Jhadeswar Shundi, my lord.
Jhadeswar?
Shundi.
SUNDI.
SUNDHI.
DHI, okay. So, what sort of injury he has sustained?
Injury is grievous, my lord.
How many?
Stab injury.
Oh.
Stab injury, my lord, over left lower lip.
Lower limb.
Rib, my lord. Rib.
Oh, rib.
My lord. Another is
the weapon of assault is?
Weapon is, my lord, one injured says Babula Marana ହଠାତ୍ ରହିଛି
ପଢିଯାନ୍ତୁ ସେଟା ପଢୁନାହାନ୍ତି
ସେଇ ସମୟରେ ମୁଁ ମନ୍ଦିର ପାଖରେ ରୋଡରେ ଇଲେକ୍ଟ୍ରିକ ଗ୍ରିଡ୍ ଷ୍ଟେସନ ପାଖରେ ଠିଆ ହେଇଥିଲି ହଠାତ୍ ବାବୁଲା ମହାରାଣା ପିଟିସନ ଓ ତାର ପୁଅ ରାକେଶ ମହାରାଣା ମୋ ପାଖକୁ ଆସିଲେ ହଠାତ୍ ରାଗିଗଲେ ଶୁଣେ ବୋଲି କହିଲେ ତାପରେ ସ୍ଲାଙ୍ଗ ଲାଙ୍ଗୁଏଜରେ ଗାଳି ଦେଇ କହିଲେ ମତେ ଧରି ପକେଇଲେ ହଠାତ୍ ରାକେଶ ମହାରାଣା ମତେ ଜୀବନରେ ମାରିଦେବାକୁ କହି ଛୁରୀ ସାହାଯ୍ୟରେ ମତେ ବାମ ପଟେ ପେଟ ଓ ମୁଣ୍ଡ ପାଖରେ ଜୋରରେ ଛୁରୀରେ ମାଇଲା। ତାପରେ ବାବୁଲା ମହାରଣା ଲାଠିରେ ମତେ ପିଟିଲା। ଫଳରେ ମୋ ମୁଣ୍ଡ ଓ ପେଟରୁ ଜୋରରେ ରକ୍ତ ବାହାରିଲା, ମୁଁ ତଳେ ପଡ଼ିଗଲି।
So this allegation against this man
Hello.
is that he is assaulted by means of a lathi.
Hello.
Any injury which is caused by lathi as per the injury report?
No, two injuries are there. One is lacerated wound over left eyebrow. Simple. That is simple. And another is stab injury.
Stab injury obviously attributed to the son of the appellant.
Yes. And petitioner is having 7 criminal antecedents.
Okay. You filed then that. Have you filed the comprehensive affidavit? You have got 7 criminal antecedents. Take the details and file it. The learned counsel for the state during course of argument pointed out from the case diary that the appellant is having 7 criminal antecedents. Learned counsel for the appellant seeks some time to obtain instruction about the status of the case and file a comprehensive affidavit to that effect. List this matter will be commencing from 31st July 2023. Yes.
Item number
65 press matter.
Press matter, same order.
Item number 66.
It's a press matter, Mr. Mahapatra. Item 66.
Yes, ma'am.
Okay, same order.
Item number 67.
Press matter.
Press matter, same order.
Item number 68.
Mr. Puntia, press matter.
Ma'am.
All right. Please take us.
ସେ ଯୋଉ ପ୍ରମୋଦ ଟିକେ ସେ ଯୋଉ ପାରାଗ୍ରାଫ କ୍ଲୋଜ କରିଛନ୍ତି ସେତିକି candidate
not applicable in the case in hand at the Baravati Kotak Assembly constituency is a general seat and not reserved for SC or ST candidates, and therefore the nomination paper does not require a declaration by a candidate specifying the particular caste or tribe of the candidate.
ଏଇଥିରେ କଣ୍ଟିନ୍ୟୁଡ ହବ ପାରାଗ୍ରାଫ 56 ରେ ସାରଙ୍କୁ ଦେଖାନ୍ତୁ 34(1) Section 34(1) of the RP Act 1951 prescribes that a candidate shall not be deemed to be duly nominated for election from a constituency unless he deposits or causes to be deposited in the case of an election from an assembly constituency a sum of ₹10,000 or where the candidate is a member of a scheduled caste or scheduled tribe a sum of ₹5,000.
Which provision?
34(1) deposit ta
1B.
That deposit has been made in this case. In terms of section 34 of the RP Act 1951, which requires a candidate to deposit a sum of rupees. What is the amount? 10,000. In case of
or where the candidate
assembly constituency
10,000 as security deposit.
As security deposit, the respondent has deposited. No, you don't do waste time. Deposited the amount. Yes, next. Yes.
AX.
AX. And this said original money receipt has been filed along with his first set of nomination paper.
Exhibit AX has been filed.
That is there. That is already there. That is there. Yes. Next question.
The respondent Mohammad Mokim in his nomination paper in Form 2B under its Part 3 after item E has deleted the first subparagraph that is first asterisk. I further declare that I am a member of double asterisk caste tribe which is a schedule double asterisk caste and tribe of the
nomination paper. No, please refer to that nomination paper and which one has been deleted?
My lord, kindly go to exhibit 38.
Yes.
At page 359.
এইটা ওটা ডিলিট করছি কোন তো?
So the first paragraph appearing after item E of part 3.
Page
359, my lord.
Yes. Yes.
The above subparagraph is absolutely not applicable nor relevant for the respondent Mohammad Mokim.
Which paragraph? Para 3A?
3E.
Part 3. So they come to next page 359 ଇ ଅଛି ଗୋଟେ ଆଇଟମ ତାପରେ
No, no, part 3 ro কোটা applicable নয়
କୋଉଟା ଇ ର ଇ ପରେ ଫାର୍ଷ୍ଟ ସବ୍ ପାରାଗ୍ରାଫ ଦେଖନ୍ତୁ
I further declare that I am a member of so and so
Again.
caste. That he has not kept it.
Again.
that has been
Deleted.
Deleted.
Again.
Part 3 টা কিন্তু ଦେଇଛନ୍ତି সেটাও delete କରିଦେଇଛନ୍ତି
Again.
so ଦେଖିଲେ କି ଆପଣ ସେଇ portion ଟା delete କରିଦେଇଛନ୍ତି
ତା ତଳେ ଦେଖନ୍ତୁ ଦିଟା ଆସ୍ଟାରିକ ଚିହ୍ନ ଅଛି ଏଠି ଆସ୍ଟାରିକ ଚିହ୍ନ ଅଛି ମାଇ ଲର୍ଡ ଆପଣ ବି ଦେଖୁଥାନ୍ତୁ ଆସ୍ଟାରିକ ଚିହ୍ନ ଅଛି ଏବଂ ତଳେ ଆସ୍ଟାରିକ ଚିହ୍ନ ଅଛି ସ୍କୋର ଆଉଟ୍ ଦିସ୍ ପାରାଗ୍ରାଫ if not applicable
single asterisk ଅଛି
single asterisk ଅଛି ଏଠି ମଧ୍ୟ single asterisk ଅଛି
The above subparagraph is absolutely not applicable nor relevant for the respondent Muhammad Mokim as he is qualified and not disqualified under Section 5A and Section 33(2) of the RP Act 1951, and he is not claiming that belongs to SC or ST and has deposited rupees 10,000. That not applicable.
In exhibit 38 by 3. Just a minute. In exhibit 38 by 3, that is the nomination paper in form to be, in part 3, there is a declaration which a candidate is required to furnish, that is inverted comma ভিতরে I further declare right
I further declare that I am a member of the which dot out of the what is into the theta asterisk তারপরে caste/tribe which is a schedule theta asterisk caste/tribe of the state of in relation to in relation to তারপরে bracket area bracket end in that state
inverted comma end. The respondent has deleted this portion in his 4 sets of nomination papers by exhibit 39, exhibit 40, 41 and exhibit 42. Stop. There is a mention in exhibit 38 in part 3
at the end of the
at the end by giving asterisk, score out this paragraph if not applicable, and double asterisk, score out the words not applicable,
not applicable inverted ରଖନ୍ତୁନି ଏଇ ପ୍ରଥମ ଆଷ୍ଟରିକ ଠାରୁ inverted ଆରମ୍ଭ କରିଦିଅନ୍ତୁ ପ୍ରଥମ ଆଷ୍ଟରିକ କରିଦେଲେ ପରେ
ବାସ୍ ସେଇଥିରେ କରିଦେବା ସେଟା ଆରମ୍ଭ କରିଦେବା
applicable ପରେ stop
stop
କରିଦେଇକି inverted sign
yes ସେଠି ଦେଲା
କହିଲେ ଯୋଉଟା it is not applicable for the respondent under section 5A
अच्छा ये this particular paragraph this particular paragraph which has been deleted by the respondent in his nomination paper সেই চারটা এখন নিয়ে আসুন exhibit 39 to ये is not applicable to the respondent. Sir.
Section
Good.
Pursuant to section 5A.
Put a 5A of the in view of section 5 capital A.
Capital small a. Bracket. Section section 32 bracketed 2 of the RP Act 1951.
32 na 33?
33. 33 of.
And the respondent has deposited his scheduled deposit.
Next.
And he is not claiming himself to be a scheduled caste or scheduled.
The respondent has never claimed himself to be a member of scheduled caste or scheduled tribe. SC or ST code. Yes, sir. Next question.
Deletion of a first subparagraph after item E under paragraph part 3.
Part 3.
Of form 2B by the respondent cannot be categorized as a defect of substantial character. Yes, sir.
Look on deletion of the above subpara in part 3 of the nomination paper in form to be filed by the respondent is not a defect of substantial character.
Yeah. The respondent in his nomination paper in form 2B has also deleted item CII under part 3.
Nomination paper my lord, that is available in page 358. 358. Part 3 there.
ତାଙ୍କୁ ବହି ଦେଇଛନ୍ତି ତ 358
ଆଜ୍ଞା part 3 ରେ ଦେଖନ୍ତୁ ଗୋଟେ ଅଛି capital letter A B ପରେ ପରେ strike out CI or CII below which is not applicable.
ସେ କଣ କରୁଛନ୍ତି
C ର II ଟା total delete.
ଆଚ୍ଛା
It is applicable for registered unrecognized political party candidate and independent candidate.
अच्छा unregistered अच्छा ओके और 2 टाକୁ ଇଏ କରୁଛନ୍ତି ସପାରା କରୁଛନ୍ତି in exhibit 38/3 comma in part 3 there is an instruction to strike out.
Strike capital inverted
strike out तापर लिखंतु C Roman 1 bold कहीं to strike out तापर लिखंतु C छोटो C bracket रे 1 Roman 1 or say छोटो C Roman 2 below all capitals से जो onje अच्छी below कर दें पूरा capital होगा पर whichever is not applicable inverted M and the respondent in his nomination papers has deleted C2 आज सर सेटा रीजन होची same is applicable
CI1 is applicable to it.
as only C1 is applicable to him. Sir.
And C2 is applicable for
and C2 is applicable for the candidate of registered unrecognized political party and independent candidate.
এটা টোটাল কভার হয়ে গেল এটা তো proviso to rule 4 ଆସିବା proviso to rule 4
नहीं सर गोटे जीवा आपण से जस्ट a minute आपण रोमा पार्ट 2 टा को काहे की काटिले से विषय क्लारिफिकेशन नहीं आइले फॉर्म टू बी गला तापर पार्ट 3 रो जोडा काटिले तार क्लारिफिकेशन सेम सीरियली करे नहीं आसो आ कोन काटि जो
सेटा कंप्लीट हे
आ कोन रहला
सेटा टिके रूल 4
को जाई कि
रूल 4 ए रो प्रोवाइजर टा पाइ रूल 4 ए अच्छे ठीक तार प्रोवाइजर टा पढो पूरे पढि दो
provided that a failure to complete or defect in completing the declaration as to symbols in a nomination paper in Form 2A or Form 2B shall not be deemed to be defect of a substantial character within the meaning of subclass 4 of Section 36.
Section 36. A C2 रे देखंतु जे सिंबल लवर प्रोविजन अछि I and triple I.
What is the question, sir?
Question hauji proviso to rule 4 of conduct of election rules 1961 prescribes that a failure to complete or defect in completing the declaration as to symbols in a nomination paper in Form 2A or Form 2B shall not be deemed to be a defect of substantial character.
Declaration as to symbols.
Again.
Symbols mean what do you mean?
CII ता देखो
को चिन्ह से पाइबो
58 नंबर पेज बहिटा एचबीआर टा
हां नहीं एटा माने एक केस रे कोन रेलेवेंस
तो CII ता
CII काटिले जोटा सेथरे से देबे जे ताकर चिन्ह कोन
ओके
किंतु जोना रिकॉग्नाइज्ड पॉलिटिकल पार्टी कैंडिडेट ताकर चिन्ह ऑलरेडी
अच्छा
सेट आउट है कि रही
एथरे चिन्ह दबार अछि प्रोविजन I and ट्रिपल I से बहिटा देखले मेलर स्टैंड
ए वही
हां 358 नंबर ओटा दो पैराग्राफ ता काटि दे सी डबल
ठीक है
358 CII ता पढंतु सेटा तळे लेखा आइछि last line ता
and the symbol reserved for the above parties allotted
सेटा CII ता देखि रखितन CII ता जोटा काटि पोती last line ता बोलछि and that the symbols I have chosen in order of preference are true and so on so
okay
सेटा ताको applicable नो
देन डिफेक्ट न देले भी जणे जदी कैंडिडेट जणे अनरजिस्टर्ड पार्टी रो हे थांदा न देले भी दैट इज नॉट ए डिफेक्ट ऑफ सब्सटेंशियल कैरेक्टर भी प्रोवाइडेड टू फॉर रूल 4A go.
I submit one thing, my lord.
Yeah.
Let witness say He is not saying whether it is applicable or not. Everything is being recorded.
No.
Let he should say.
No, everything is asked by the court.
Aଜ୍ଞା ସେ କହୁ ଆଗେ ସେ କିଛି କହୁ ନାହିଁ. He is just sitting.
If Mr. Agrawala, they have a right to put leading
Yes,
questions.
Lord.
And the witness says yes, so what can be?
He must say yes. He is not saying
No,
anything.
he's saying yes.
He
So
is not saying anything.
no. So this question you agree? Section, please you come to this side, please. You come to this side. When there is objection, please come to this side. So that is why I was asking you, please come here, because they are objecting that unnecessarily. Rule 4, proviso
to rule 4.
Please, proviso to rule 4 of
capital A.
Please.
Like for A.
No, if you tell one thing, I will stop here.
Sorry, ma'am.
Please sit to that. No, please go to that of RP, Conduct of Election Rules, 1961, prescribes that a failure to complete or defect in completing, failure to complete, and a failure to complete or defect in completing, the declaration as to symbols in a nomination paper in form 2-A or form 2B shall not be deemed to be a defect of a substantial character within the meaning of subsection bracket 4 of section 36. Yes, sir. Next question.
For A. Rule for A.
What 4A?
The rule for capital A.
No.
4.
His question is being put, that is there in that
4.
Yes.
Therefore, deletion of item number CII under part 3 of form 2B by the respondent Muhammad Mokim cannot be categorized as a defect of substantial character. Yes, ma'am.
In my view, deletion of C, small c, deletion of bracket with a small c, bracket with a out of bracket with a Roman 2. In part 3 of his nomination papers filed by the respondent is not a defect of a substantial character. Sir.
Under subsection 3 of section 33, it has been prescribed that where a candidate is a person who, having held any office referred to in section 9, has been dismissed and a period of 5 years has not been elapsed since the dismissal, such person shall not be deemed to be duly nominated as a candidate unless his nomination paper is accompanied by a certificate issued in the prescribed manner by the Election Commission to the effect that he has not been dismissed for corruption or disloyalty to the state.
Who provided?
Subsection 3 of section 33. देखो.
Next, the rule.
ମୁଁ ଦେଖିଦେଉଛି।
1950 ଗାଡ଼ି।
No, 51 right.
51, the reference has been given to
subsection 3 of section 33.
Section 33, subsection 3.
3. Where the candidate is a person who, having held any office referred to in section 9, has been dismissed and period of state again.
Again. Sir, what is your question?
एटा मु देखैली तापर मोर क्वेश्चन होची इन द इंस्टेंट केस respondent in his nomination paper in form 2B under its part 3 capital A against item number 2 has declared that he is not holding any office of profit under the government of India or state government, and against its item number 6 has further declared that he was not dismissed for corruption or for disloyalty while holding office under the government of India or government of any state.
Who quote is the declaration?
Nomination.
Part 3 capital A.
Part 3 capital A.
Item number 2 or item number 6.
Item number 2.
Again.
Whether the candidate is holding any office of profit under the government of India or state government, no.
Again.
So whether the candidate has been declared in 8 and whether
6.
Then 6. Whether any candidate was dismissed for corruption or for disloyalty. Or that is answer is no.
Again.
All right. That is required in terms of this provision.
Again.
What do you say?
Again.
Okay. The respondent in his nomination papers in form 2B, that is mark ordinance jo charta exhibit ne asuntu, has mentioned in part 3A bracketed 2
Under this item 2.
Under item number 2. Under item number 2 that he is not holding any office of profit under the government of India or the state government, and further he has mentioned in part 3A under item number 6 that he was not dismissed for corruption or for disloyalty while holding office under the government of India or the government of any state, and the same
respondent is not disqualified under section 9 of the RP Act 1951.
नहीं आपण जो 33(3) टाକୁ रेफर कले आपण
हां सेटा का परटा का
Section 9 टा ଅଛି ना.
अच्छा पचरंत चले.
Therefore, Muhammad respondent is not disqualified as prescribed under section 9 of the RP Act 1951, and he shall not be deemed not to be duly nominated as a candidate in the election in question as prescribed under subsection 3 of section 33 of the RP Act.
9 टाକୁ देखंदु.
Kali sir pachal.
हां खाली 50.
Yes sir, yes sir.
All right. And the respondent is not disqualified under section 9 of the RP Act sir.
ସରିଲା କହିଛି ପଚାରୁଛି ମୁଁ ରେକର୍ଡ ହବ ନା ଆଉ and he shall not be duly nominated as a candidate deemed not to be duly nominated as a candidate in the election in question as prescribed under subsection 3 of section 33 of the RPI.
And এটা ঠিক তো
আচ্ছা,
সেটা দিও
33(3) and he shall not be
হুম
deemed not to be duly nominated as a candidate in the election in question as prescribed under subsection 3 of section 33 of the RPI.
yes.
Moreover, there was no objection
Yes, no objection.
to such declaration of the respondent.
Stop. There was no objection. Moreover, what use karantu? Moreover, come out adiyantu. There was no objection to the declaration of the respondent
By anybody. Before you.
A objection karno before me. Moreover, there was no objection to the declaration of the respondent by anybody before me.
Contradicting such statement.
Acha, contradicting such statement.
Right. Section 5, subsection 5 of section 33 देखो.
Again.
Subsection 5 of section 33 of the RP Act 1951 prescribes that where a candidate is an elector of a different constituency, a copy of the electoral roll of that constituency or of relevant part thereof, or a certified copy of the relevant entry in such roll shall, unless it has been filed along with the nomination paper, be produced before the RO at the time of scrutiny.
Yes.
In the instant case, respondent being an elector of 90 Baravati Kotak Assembly constituency under its proviso to 70, part 70, by serial number 111. Therefore, this is not applicable. This is not
Section
applicable
33 bracket 5 of the RP Act. Subsection 5.
Subsection 5
is not applicable to the respondent as he is an elector of 90-Baravati Kotak in which he was contesting the election as MLA. Sir.
Under Part 1 of Form 2B, Exhibit 39, 40, 41, 42, it has been mentioned that the name of respondent Muhammad Mukim, sorry, wala. Acha. You being the returning officer at the time of preliminary examination of nomination papers delivered by respondent on 2/4/2019 and after verifying the original final voter list for the year 2019 for 90 Baravati Kotak Assembly constituency became satisfied that the respondent Muhammad Mukim is an elector of 90 Baravati Kotak Assembly constituency and his name has been entered in part 70, serial number 1112 of the said constituency.
Yes, ma'am.
You documents you file करथिले ताको nomination paper सहित you are satisfied that he is an elector of so and so.
Yes.
Acha, after verifying the documents filed along with the 4 sets of nomination papers in Form 2B by the respondent, comma, I was satisfied that the respondent is an elector of 90 Baravati constituency. Yes.
Clause B of subsection 7.
Verifying the documents in Form 2B by the respondent as well as the original voter list.
ତା ଦେହରେ ତ ଅଛି ଆଉ ସବୁ ଅଛି
ସେଟା
voter list.
ଦେଇଥିଲେ photocopy original ଟା
Why are you anybody disputing?
Nine.
So, yes, next.
Clause B of subsection 7 of section 33 of the RP Act 1951 prescribes that notwithstanding anything contained in subsection 6 or in any other provisions of this act, a person shall not be nominated as a candidate for election in case of a general election to the Legislative Assembly of a state, whether or not he held simultaneously from all assembly constituencies from more than 2 assembly constituencies.
The course provision kinetic.
ସେଟା ଦେଖନ୍ତୁ
36(7) of B clause B ଟା ଦେଖ.
ହଁ.
B ଟା next page ରେ ଅଛି.
ଆଜ୍ଞା.
A ପରେ B ଅଛି.
ଆଜ୍ଞା.
ଦିଟା ଜାଗାରୁ ଅଧିକାରେ ଠିଆ ହେଇ ପାରିବ ନାହିଁ.
ଆଜ୍ଞା. Yes.
ପଚାରନ୍ତୁ sir.
ଆଜ୍ଞା.
Next question.
In the instant case, the respondent in his nomination form 2B କହିବା ଦରକାର ନାହିଁ. The respondent in his nomination form 2B under part 3 at its last subparagraph has declared that he has not been and shall not be nominated as a candidate at the present general election or / by-election being held simultaneously to the State Legislative Assembly of Orissa from more than 2 seats.
Yes, madam.
That is in part 3, the last subparagraph, right?
Yes,
I also declare that I have not been, comma, and shall not be nominated as a candidate at the present general election / by-election being held simultaneously to the Legislative Assembly of Orissa from more than 2 assemblies. All right. As per the requirement, subparagraph. As per the requirement in section 33 bracket 7 bracket B of the RP Act, comma, the respondent in his nomination papers in Form 2B, that is exhibit so and so, has mentioned, has declared under part 3 that he has not been, comma, and shall not be nominated as a candidate at the present general election / the by-elections the by BYE by-elections एस्टा लगी होता है BYE by-elections being held simultaneously, comma, to the Legislative Assembly of Odisha from more than 2 TWO assembly constituencies. Stop. He has declared under part 3 that he has not been and shall not be nominated as at the present general election. The violation being held simultaneously to answer. Yes, sir.
Again. Therefore, respondent is not falling under ambit of clause B of subsection 7 of section 33.
According to me, the respondent is not coming under section 33 RPA.
Moreover, there was no objection by anybody before you. Yes, ma'am.
Sir.
Subsection 4 of section 33 ta dekho.
Subsection 4.
Again.
Sir.
Prescribes that on presentation of a nomination paper, the RO shall satisfy himself that names, electoral roll numbers of the candidate and his proposer are entered in the nomination paper are the same as entered in the nomination paper are the same as those entered in the electoral roll.
Yes.
You verify.
Yes.
In all 4 sets of nominations.
As per subsection 4 of section 33 of the RP Act 1951, on the presentation of a nomination paper, as returning officer, I shall have to be satisfied myself that the names and electoral roll numbers of the candidate and his proposer as entered in the nomination paper are the same as those entered in the electoral rolls. Stop. After verifying the 4 sets of nomination papers filed by the respondents in Form 2B,
as well as all other candidates.
As well as other candidates, who
filed a nomination for 90 Baravati Assembly.
Who filed nominations for 90 Baravati Kata constituency. Sir, कौन एटा जे एटा follow a page will, this provision has been strictly followed.
Proviso to subsection 4 of section 33 of the RP Act.
माने कहा केस रे डेविएशन नहीं नथला, केवल रेस्पोंडेंट में कहा केस रे मध्य जी भी जो फाइल करथिला जो प्रपोजर करके सब गुडा को सेही ये रथिला. On the presentation of the nomination, returning officer shall satisfy himself names and the electoral roll numbers of a candidate and his proposer. तमने सार एठी गोटे वार्ड टा ऐड करे ना all other candidates मु सेहित में पहुंचल. Then खाली हमर थाओ खाली as well as all other candidates काटी दियन. से respondent
Proviso to Proviso to subsection 34 of section 33 of the RP Act 1951 provides authority and power to returning officer to
Just sir,
permit.
wait a minute. After verifying the 4 sets of nomination filed with honor, I find that this provision has been strictly followed by the respondent. Yes, sir.
ଏଇଟା ସିଏ କଲେ ନିଜେ କରିକି ଦେଖିଲେ ସିଏ ନିଜେ
I find परा सर मु पाई ये कल जे से जो प्रोविजन टा रिक्वायर्स अछि ना से the names and electoral of the sworn is present ये मु satisfy हेली जे से ताकू strictly follow करिसेंती ठीक अछि सर
Proviso to subsection 4 of section 33 of the RP Act 1951 provides authority and power to returning officer to permit any misnomer or inaccurate description or clerical or technical or printing error in the electoral roll or in the nomination paper to be corrected.
Yes.
Okay. Section 33 as a proviso to section proviso to subsection 4 proviso to subsection 4 bracket of section 33 of the RP Act 1951 provides that as returning officer I can permit any misnomer or inaccurate description or clerical, technical or printing error to be corrected. ଆଉ ଗୋଟେ sir ତା ଦେହରେ ଅଛି ଏକାଡି
Overlook ବି କରିପାରିବି
ଆଉ ଗୋଟେ ଅଛି ଦେଖନ୍ତୁ overlook କରିପାରିବେ and when necessary comma direct that such misnomer comma inaccurate description comma clerical technical or printing
in the electoral roll or the nomination paper
to be overlooked. Overlook टा गोटे word hyphen टा काटी दंतु आउ थरे पढिया टिके रोन proviso to subsection 4 of section 33 of the RP Act 1951 provides that as returning officer I can permit any misnomer or inaccurate description or clerical, technical or printing error to be corrected and when necessary, comma, direct that such misnomer, inaccurate description, clerical, technical or printing error in the electoral roll or in the nomination paper to be overlooked. Sir, ठीक है, पचाऊँ.
The alleged defects, deletions, omissions in the nomination paper in Form 2B of the respondent being not of a defect of substantial character and such alleged defects, deletions, misnomers, omissions, deletions, omissions are coming under category of misnomer, inaccurate description, clerical, technical or printing error, and being an arrow, you have power and authority to overlook the same and you have overlooked the same.
Yes, my lord.
जो गुड़ाक छाड़ी दी जाइछंती बा
Delete
डिलीट कर दी जाइछंती सेगुड़ाक आपणकर सारंकर प्रश्न होची सेगुड़ाक आपणकर पावर अछि जे जेहेतु सेगुड़ाक ओवरलुक करिया पई इन व्यू ऑफ दिस पर्टिकुलर प्रोविजन
Yes, my lord.
एवं सेथि पई जदियो से किछि प्रोविजन डिलीट कर दैछंती
My lord.
सेटा को आपण ओवरलुक करछन
Yes, ma'am.
एया सर पचास यू एग्री विथ इट
Yes.
ऑल राइट by exercising it नहीं सही तरह कंटिन्यू कर दें by exercising my power conferred under subsection 4 under the proviso TO2 subsection 4 of section 33 of the RP Act 1951, I have overlooked the misnomer, in आउ कौन सर कहउछंती
गोटे कहि दो
हां
overlook the alleged defects.
overlook the alleged defects
overlook the alleged defects
deletion
/
omissions in the nomination paper in form 2B of
the respondents
as the same were not a defect of substantial character.
I have sir से wording गुड़ा को रहिलानी sir से जो misnomer enough सेटा रहिलानी हां सेटा आपण सेटा पचार थिले एठी आ कहिलेनी
and such alleged defects, deletions, omissions being coming under category of misnomer.
अच्छा फिर लिख दो मिस नहीं सेटिन नहीं omission पर लिखो in the nomination paper ये जो respondent पर
omissions पर
of the respondent the same was not defined
तापर पर substantial character ने my lord ठीक अछि तापर and
अच्छा ठीक है
and such
हां से ठीक है and सर कोन
and such alleged defects deletions omissions being coming under category of misnomer, inaccurate description, clerical, technical or printing errors. As a returning officer, I have power and authority.
I have the power. I have overlooked it. I have overlooked the same. I have overlooked it. मोर ऊपर को होची पावर अछि किंतु एई जो एई टाइप रो जेहेतु सेटा आइतला मु ताको ओवरलुक कर दै छी हां
under part 3A of form 2B against its item number 1 the candidate is required to furnish information as to whether italic I the candidate has been convicted A of any offences under subsection 1 or B for contravention of any law specified in subsection 2 of section 8 of representation of the People Act 1951.
एटा सर अछि तो ठीक अछि
आगे
एटा मन देछि पार्ट 3 रे
आगे
हां 55
I has been convicted for any other offences for which he has been sentenced to imprisonment for 2 years or more or not. If the answer of the candidate to the above effect is yes, then the candidate shall furnish information as mentioned against I to XII available under item 1 of part 3A of form 2B.
जोड़ा किसी किछि फिल अप करनी एटा फिल अप करथांदा जदी माने आंसर जदी ये सही थांदा ताले सेडा को फिल अप करथांदा जेतु आंसर नो अछि फिल अप करना दियो
माय लॉर्ड एग्जिबिट 42 रे फिल अप करछन
हां
एग्जिबिट 42 आपण पाके सिटा अछि
ताले गोटे गोटे देखांतो आपण जदी अलगा अलगा अछि ମୁଁ ଧରିଛି exhibit 40 ଧରିଛି exhibit 40 ରେ fill up ହେଇନି exhibit 39 40 41 ରେ fill up ହେଇନି କେବଳ 42 ରେ fill up ହେଇନି ତାହେଲେ ଦେଖାନ୍ତୁ
ଫଟୋଟା ସାରଙ୍କୁ ଦେଇଦଉନା
not applicable mention was NA ଲେଖିଛନ୍ତି
ହଁ ସେଟା ଏନେ କିନ୍ତୁ ଏଇଟା ପୁରା ବ୍ଲାଙ୍କ ଛାଡିଛନ୍ତି ଆଉ ତିନିଟା ସେଟରେ ବ୍ଲାଙ୍କ ଛାଡିଛନ୍ତି ସେଟାରେ ଏନେ ଲେଖିଛନ୍ତି ସବୁ ଗୁଡାକ ଇଏରେ ଏନେ ଲେଖିଛନ୍ତି ନା ଗୋଟେ କୋଉଠି ଏନେ ଖାଲି ଲେଖିଦେଇଛନ୍ତି ଏଇ ଯେତିକ କଲମ ଅଛି ରୋମାନ
NA ଲେଖିଛନ୍ତି my lord
ସବୁ ନାଇଁ ସାରଙ୍କର ପ୍ରଶ୍ନ ହଉଛି 1 to XII ଏ ସବୁଥିରେ ଏନେ ଲେଖିଛନ୍ତି ନା କିଛି ରେ ଏନେ ଲେଖି ଛାଡି ଦେଇଛନ୍ତି ନହେଲେ ମତେ ଦେଖାନ୍ତୁ ମୁଁ ଲେଖିଛନ୍ତି
ସବୁଥିରେ ଲେଖିଛନ୍ତି ଗୋଟେ ଆଇଟମ ଏସ୍ ର ନୋ ଲେଖିବା କଥା ଏକ୍ସଟ୍ରା କାଟିଛନ୍ତି ନୋ କରୁଛନ୍ତି
12ଟା
ହଁ ଗୋଟେରେ ନୋ ଲେଖିଛନ୍ତି ଆଉ ସବୁଥିରେ ଲେଖିଛନ୍ତି 12ଟା ଅଛି 12ଟାରେ ଲେଖିଛନ୍ତି my lord
ତାହେଲେ ବାକି ସବୁରେ ଏଗୁଡାକ ବ୍ଲାଙ୍କ ଅଛି ଆଚ୍ଛା in 3 sets of nomination paper
requirement my lord
in 3 sets of nomination paper that is exhibit 39 40 and 40 and say 42 ta kati comma in part 3A
against item 1
comma a part 3A comma against item number 1 I bhaliya kon
1 ek
ha bracket bhitar kon hai na where the candidate comma if convicted of any offense bracket is from under subsection 1 comma roman jo semicolon diyantu or for contravention of any law specified in subsection bracket 2 of section 8 of the RP Act, 1951, the respondent
or
has been convicted for any other offense ପରେ ଗୋଟେ s ରହିବ for which he has been sentenced to imprisonment for 2 years or more, the respondent has mentioned capital inverted comma bhitere no no inverted comma and therefore he has not filled of Roman 1 TO2 XII
appearing under
item number Roman item number 1 son.
Part 3A.
However, in exhibit 42 comma সেই লেখন্তু in part 3a so and so সেটা কপি করে দেন in part 3a সেটা নিয়ে যান সেটা নিয়ে যান item number 1
नो पड़ता
पूरा नहीं जान comma comma he has mentioned
दिखाई दे नो he has filled up
he has filled up he has filled up
I2X
Roma से जो कुछ आगे पढ़ा से जो
from bracket I2XI
से जो लिखते हैं mentioning
filled up I
Roman 1 TO2 XII
appearing under item 1
appearing under item number 1 आज नहीं कौन लिखी एन ए लिखी पूरा
गोटे करे माय लॉर्ड देखिए माय लॉर्ड गोटे भी ट्रिपल आई रे लिखि जंती नो
अच्छा ठीक अछि आज एन ए इन ऑल दी clauses except clause V
I तीनटा 8 है it is no to requirement अछि had mentioned no
where he has mentioned no no ठीक है ताने बाकी गुडा सब एन ए लिखछन्ती सेई गोटाकर खाली नो लिखछन ठीक है एटा हे गला पूरा सब कवर कला कारण एटी क्लियरली कोजी आंसर जदी यस हे थादा ताले गुडा को फिल अप कर ठीक है ठीक
non filling up 1 to XII appearing under item number 1 of part 3A of form 2B by the respondent, particularly when he has furnished information against item number 1 of part 3A as a no, the same is not a defect of substantial character.
Yes, ma'am.
The non-filling of
I2XI
Roman I से जो
कॉपी कर लिया I2XI appearing under item number 1 पर
से तो नहीं आसन
item number 1 पर कॉपी
in से तीनटा एग्जिबिट नहीं होती in अच्छा आइटम नंबर 1 अंडर पार्ट 3 अकाउंट अंडर पार्ट 3 सीट अंडर पार्ट 3
माय लॉर्ड सर ऊपर सेंटेंस मध्ये अछि आइटम नंबर 1 सेठी आ पार्ट 3 रो सेकंड सेंटेंस
माय लॉर्ड
part 3a in clause so and so the non-filling of so and so under item appearing under item number 1 under part 3a अच्छा सेटा appearing in এটা in कर दियन तो under न करी कि in कर देगा दीटा under रही है जो भल सुबनी the non-filling of so and so in item number 1 under part 3a in so and appearing
after item number 1 सरला परे
कोटा
सेटा under
नामो सेटा 8 1 रो गोटे पार्ट टा और ठीक है in so or लिखंतु or mentioning as NA or no NO फिर अभी ये भी तो ऐसे नोटा ठीक है लानी तब पूर्व जो अपोस्ट्रोफी स्टा जो भी तो ठीक है तो हाँ in in the clauses under you 1 to XI करते in exhibit 42 is not a defect of substantial character, defect of a substantial character, particularly when the respondent has mentioned as no against item number 1.
Moreover, there was no objection before you with respect to the above by anybody.
Yes, my lord.
ସେଟା ନେଇ ଆସନ୍ତୁ କପି କରି ପେଷ୍ଟ କରିଦିଅନ୍ତୁ। ନାଇଁ ନାଇଁ ଆଉ ଟିକେ ବ୍ୟାକ୍ କରିଦିଅନ୍ତୁ। Right.
And as a returning officer,
Sir.
You have overlooked the same and accepted all the 4 sets of nomination papers of the respondent as valid in exercise of your power conferred upon you under proviso to subsection 4 of section 33 and subsection 4 of section 36 of the RPA.
Yes, my lord.
As returning officer, I have exercised my power conferred under subsection 4 proviso to under the proviso TO2 subsection 4 sir I would कोनटा कहले
And subsection 4 of section 36.
हां सेटा तो गला section 30 I would कोन कहले
subsection 4 of section 36.
36
and subsection 4 of section 36 ticket here 36 टा कोन असला
Substantial character.
36 रो 4 हां substantial correct.
Against item number
sir ticket as returning officer I have exercised my power conferred under so and so and sir माने कन्फर कर पावर जे मु रेस्पोंडेंट रो नॉमिनेशन कोन सर आपन क्वेश्चन थिला
you have overlooked.
हां अच्छा आ कमा I have overlooked the such non-feeling as the same here लिखा होगी as the same were not the defect of a substantial character sir
And have accepted the nomination.
and accepted the nomination paper in the case of respondent
All the 4
accepted the 4 sets of
all the 4 sets.
accepted all the 4 sets of nomination papers of the respondent in case of the respondent of the respondent sir
Against item number 3 of part 3A of form 2B, against the first sentence, the candidate is required to furnish information as to whether the candidate has been declared insolvent by any court or not. देखिए हमसे
part 3A
again.
हाँ सर कोड
item 3
item number 3 अच्छा हाँ सेटा गोटे आपण धरिचन तो ये
Yes, my lord.
हाँ
Again.
whether a candidate has been declared insolvent by any court से लिखचंती no
Or not.
हाँ से no लिखचंती या तो सर पचंद प्रश्नटा
The respondent Mohammad Mukim has furnished information against the first sentence of item number 3, part 3A of his nomination paper in form 2B as no.
Yes.
Therefore, the second sentence of item number 3 of part 3A of form 2B is not applicable and relevant for respondent.
ठीक है सर
My lord, handbook.
आपण ए बहिटा देखन ए बहिटा ए बहि रे से 3 पर रहिची जदी सिए if yes ताहले has he been discharged from insolvency सेटा से लिखि थांते एवं ता पूर्ण कर थांते से जेहेतु लेखुचंती नो बेली सारंकर क्वेश्चन होची ए जो ता पर लाइन टा जो से डिलीशन कर दैचंती जो प्रेस्क्राइब फ्रॉम को एटा सारंग क्वेश्चन होची इट्स नॉट अ डिफेक्ट ऑफ ए सब्सटेंशियल
Yes, yes.
Are you agreeing? Okay.
Now, deletion of second sentence of item number 3
is not applicable and
हाँ
सब para कर दो.
अच्छा the respondent आगे कौन मेंशन करछन्ती लिखि दो. The respondent सब गुडा करे लिखछन तो चारटा जाक सेट रे ए जो खाली सेटा भी कोथरे मेंशन करना दी तो ए जो सेकंड लाइन टा अच्छा the respondent in his 4 sets of nomination papers informed to be that is परंतु चारटा को नहीं आसंतु under item number bracket भीतर 3 under part 3A अच्छा of part 3A बोलो of part 3A
against the first sentence.
नहीं सर where अच्छा where a candidate is required to furnish information whether he had been declared insolvent by any court, comma as mentioned inverted comma with a no. Stop. In the prescribed format in exhibit 38/3 comma after the first line first sentence after the first sentence under item number 3 of part 3A comma if the answer to the first sentence would have been inverted comma bhitere yes y ta capital kar dun comma the candidate in the second sentence is required to mention whether he has been discharged from insolvency. Stop. This second sentence has been deleted by the respondent as he has mentioned no to the first sentence.
In answer to the first.
He has mentioned no to the answer to the answer no to the answer
against the first sentence.
against the first sentence. Against the first sentence.
No पर against कर दो तो काट दो. Mention no against the first sentence. To the answer against the no to the answer against the first sentence. And the second sentence is not applicable.
Has been deleted. It's here. And the second sentence is not applicable. Stop.
And relevant for this.
According to me, the डिलीशन आपण कहउछन जो सेकंड लाइन टा जो सेंटेंस टा डिलीट कले एटा इज नॉट ए डिफेक्ट ऑफ सब्सटेंशियल according to me the deletion of the second sentence under item number 3 of part 3A by the respondent is not a defect of a substantial character.
Moreover, there was no objection.
সেটা কপি করে নিয়ে আসুন তো পাওয়ারটা এক্সারসাইজ করতে হবে
कौन है
ಇದು ಇನ್ ಎಕ್ಸರ್ಸೈಜ್ ಮೈ পাওয়ার দু
and
কপি করে নিয়ে আসলে সেটা
कौन है कौन आपको से जो पावर टा एक्सरसाइज करछन से जो दीटार प्रोविजन से कौन से हां से 33 और 36 पर हां सेट लिख दूं
সেই আজ রিটার্নিং ঠার পুরা সে সেন্টেন্সটা রখি দিতাম
हां तो बाकी तो आनंद सॉल्व substantial stop which नहीं
আজ টু কিন্তু ক্যাপিটাল ছিল
এটা তো বললাম না according to deletion of second sentence of part 3 is not a defect of a substantial character
রিটার্নিং অফিসার সেই টু
who which I am which I was convinced after exercising my power under sections 1 say you I have overlooked out soda ka last task kati den say
and I have overlooked such deletions and
ସେଇଟା ସେ provision ঠিক ଅଛି টলটা কাটি দেন দরকার নেই নেক্সট স্যার
Moreover, there was no objection to the above effect.
সেটা লিখে দিন moreover there was no objection to the declaration of the respondent by anybody to such declaration sir next
Against the first sentence of item number 4 of part 3A of nomination form 2B, the candidate is required to furnish information as to whether the candidate is under allegiance or adherence to any foreign country or not.
Yes. अच्छा सी कौन लिखिछंती नो लिखिछंती जदि ये सही था डिटेल्स दे था जोटा को सी टोटल ओमिट कर दी ये तो ये जो ओमिट तार सान कर सर नेक्स्ट क्वेश्चन टा पचार देन मु लिख देबे का से जो ओमिट करले बा डिलीट कर देले जो
second sentence of item number 4 in his nomination paper form 2B by the sentence by the respondent is not a defect of substantial character.
ठीक था ओके लिखो सेम पूरा से पैराग्राफ को कॉपी कर दियो The respondent in his 4 sets of nomination papers so and so under item number 4 of part 3A where a candidate is required to furnish information whether he is under allegiance ALLEGI allegiance or adherence to any foreign country, comma, has mentioned, she mentioned no. Acha, in the prescribed format in so and so, after the first sentence under item number 4 of part 3A, comma, if the answer to the first sentence would have been yes, comma, the candidate in the second sentence is required to give details. Is required. Out it all.
Yes, the candidate in the second sentence is required to ठीक अच्छी to give mention
टू जाए ठीक है तापर से जो मेंशन टू सेट हां टू गिव डिटेल्स सेटा काटी दियंतु पूरा सेशन गिव डिटेल्स देयर ऑफ सेटा काटी दियंतु हां स्टॉप this second sentence has been deleted by the respondent as he has mentioned no to the answer against the first sentence and the second sentence is not applicable according to applicable to him according to him according to me deletion of the second sentence under item number 4 of part 3a by the respondent is not a defect of a substantial character which I was convinced after exercising my powers once. So moreover there is no objection to the yes sir
कॉपी करता हूँ ऊपरटा to him से
अच्छा और हेड टू हिम टा लिख दो
हाँ applicable
to him sir
Against the first sentence of item number 5 of part 3A of form 2B, the candidate is required to furnish the information as to whether the candidate has been disqualified under section 8A of the RP Act 1951 by an order of the president or not. If the answer to the first sentence of item number 5 of part 3A is as furnished by the candidate is yes, then candidate is further required to furnish information against the second sentence of item number 5 of part 3A, giving the period for which he is disqualified.
ठीक तो किंतु सेईटाको से काटी देइछन जेहेतु से नो लिखिछन तेणु काटिछन ए जो काटी देइछन एटा एटा डिफेक्ट ऑफ ए सब्सटेंशियल कैरेक्टर नुए या क्वेश्चन सर यू एग्री विथ the respondent in his four sets also under item number 5 where a candidate is required to furnish information whether he has been disqualified under section 8 capital A of the said act of the of RP Act 1951 by an order of the president comma has mentioned कौन लिखी से नो लिखछन ठीक है मेंशन पर नोट अटी बेसिक गैप हे गला कम हे दियंगु हां in the prescribed format in exhibit 38/3 after the first sentence under item number 5 right if the answer to the first sentence would have been yes the candidate in the second sentence is required to give the period for which he the period for which disqualified the period for which disqualified no the period for which he was disqualified sentence period for which he was disqualified this second sentence this second sentence has been deleted by the respondent as he has mentioned no to the answer against the first sentence and the second sentence is not applicable to him according to me the deletion of the second sentence under item number 5 of part 3A by the respondent is not a defect of so and so which have certificates. Next. रहिला सबुत रहउछ कॉपी पेस्ट हो जाए
Against the first sentence of item number 6 of part 3A of form 2B, the candidate is required to furnish information as to whether the candidate was dismissed for corruption or for disloyalty while holding office under the government of India or the government of any state or not. Yes.
जदि सी लिखिछंती कोन मुकिम लिखिछंती नो
No.
जदि ये सही था ताहले the date of such dismissal se mention करता है तेणु सार पचार दिन ता नेक्स्ट क्वेश्चन मुझे कर दो
ସବୁ ସମାନ ତ ଭାଇ
हाँ नहीं नहीं पचार भी नहीं
deletion of the
ये जो
second
डिलीशन टा करिसेंदी सीए according to whether it is a defect of a substantial character
Yes, it is a defect of
हाँ
substance. It is not coming under substantial defect.
हाँ सिया कोना जे yes मार दो जन देखो the respondent in his 4 sets of nomination paper in form to be in so and so under item number 6 of part 3A where a candidate is required to furnish information whether he was dismissed for corruption or disloyalty while holding office under the government of India. While holding office under the government of India or the government of any state, has mentioned, mention no. In the prescribed format, so and so, after the first sentence, so and so, if the answer to the first sentence would have been yes, the candidate in the second sentence is required to give the date of such dismissal. The date of such dismissal. Stop. This second sentence has been deleted by the respondent as he has mentioned no to the answer against the first sentence. And the second sentence is not applicable to him. According to me, the deletion of the second sentence under item number 6 of part 3A by the respondent is not a defect of so and so. Yes. Next.
subsection ଟା ବଦଳେଇଲେ subsection 4 ଥିଲା ଠିକ provided to subsection 4 କେବଳ item
ସିଆଡ କିଛି ହାତ ମାରନ୍ତୁନି
Against the first sentence of item number 7 of part 3A of form 2B, the candidate is required to furnish information as to whether the candidate has any subsisting contracts with the government, either in individual capacity or by trust or partnership in which the candidate has a share for supply of any goods to that government or for execution of works undertaken by that government or not.
যদি আনসারটা ইয়েস এই হব তাহলে কোন সে করিবে এটা পচার দিন স্যার একাটি পচার দিন তো লিখবা
If the answer is yes, then the candidate is required to furnish information against the second sentence of part 3A, giving the name of the government and details of the subsisting contract.
কিন্তু সে যেহেতু নো লেখিଛନ୍ତି ତେଣୁ ଏଠି ଦରକାର ନାହିଁ ଅଲରାଇଟ୍ ଲେଖନ୍ତୁ এটা ଆସିଗଲା ତ ସେଇ ପାରାଗ୍ରାଫ ଆଇଟମ ନମ୍ବର ରୁହନ୍ତୁ whether he has any subsisting contract ପରେ ଗୋଟେ ଏସ୍ ରହିବ with the government ହେଲା either in individual capacity or by trust or partnership in which the candidate has a share for supply of any goods to that government or for execution of works undertaken by that government, has answered selection no. In the prescribed format so and so, after the first sentence, in item number so and so, if the answer to the first sentence would have been yes, the candidate in the second sentence is required to give um, with which government is required to give information, is required to give information with which government and details of subsisting contract. Stop. Contracts. Stop. The second sentence has been deleted by the respondent as he has mentioned no to the answer against the first sentence, and the second sentence is not applicable to him. According to me, so and so deletion of
Again.
second sentence, সেটা ঠিক আছে, সেটা ঠিক আছে, 7 deletion of সেটা রহিব, হ্যাঁ, okay sir.
Against the first sentence of item number 8, the candidate is required to furnish information as to whether the candidate is a managing agent or manager or secretary of any company or corporation within bracket other than a cooperative society in the capital of which the central government or state government has not less than 25% of share or not. If the answer of the candidate to the first sentence of item number 8 of part 3A of the Form 2B is yes, then the candidate is further required to furnish the information giving the name of the government and the details thereof. The respondent in his nomination paper in Form 2B under Part 3A against the first sentence of item number 8 has mentioned no.
Second sentence ta
delete bhi kar deche.
Okay sir, the respondent in his force so and so under item number 8 of part 3A, where a candidate is required to furnish information whether he is a managing agent, comma, or manager, or gota diyan, or my comma par managing agent gota comma diyan seti, comma, or manager, or esta capital secretary of any company or capital corporation, bracket lekhantu, other than a cooperative, normal, a cooperative society, bracket ends, C taku choto ଆଉ S taku bhi choto କରନ୍ତୁ, cooperative society in the capital of which the central government or state government has not less than 20-5 नहीं पूरा लिखो 20 TW 20-5% share, comma, has mentioned no in the prescribed format in so and so after the first sentence item number it have 8 ঠিক আছে of part 3A. If the answer to the first sentence would have been yes, the candidate in the second sentence is required to give further information with which government and details and the details thereof and the details thereof. The second sentence has been deleted by the respondent as he has mentioned no to the answer against the first sentence, and the second sentence is not applicable to him. According to me, the deletion of the second sentence under item number 8 of part 3A of the respondent is not a defect of a substantial character, which I was convinced after exercising. Mark 1. Okay, yes.
Against the first sentence of item number 9 of part 3A of form 2B, the candidate is required to furnish information as to whether the candidate has been disqualified for the commission by the commission under section 10A of the RP Act or not. In answer to the if the answer of the candidate to the first sentence of item number 9 in part 3A of form 2B is yes, then the candidate is further required to furnish information against the second sentence of item number 9, giving the date of disqualification. The respondent, the respondent in his nomination paper in form 2B under part 3A against the first sentence of item number 9 has mentioned no.
सर से डिलीट करनी है एटाও डिलीट करना खाली रखा है ब्लैंक छाड़ देजन
गोटे जेमती एग्जिबिट 42 रे एनए लिखितंती आ अलगा गुरे रे ब्लैंक
মানে এই পার্টিকুলারটা কিন্তু মেনশন এই সবুটি এই যে ইফএস আচ্ছা
गोटे एग्जिबिट 42 रे
all
एनए
right বুঝিল the respondent in his fourth nomination so and so under item number 9 of part 3A where the candidate is required to furnish information whether he has been disqualified by the commission under section 10A cap hyphen 10A of RP Act or not, comma has
1951 chapter 1951
RP Act 51 or not, comma has mentioned no. Stop. In the prescribed format, so and so after the first sentence, so and so if the answer to the first sentence would have been yes, the candidate in the second sentence is required to give date of disqualification. ठीक है जी. The second sentence এটা delete करना. In the second sentence लिखो. The second अच्छा the second sentence has not been filled up by the respondent in exhibits 39, 40 and 41. पूथरे fill up हुई ठीक है देखिए दियो आउट 42 है 5 नंबर सीरियल डाल ठीक है तो and whereas in exhibit 42 comma it has been mentioned as only in the NA लिखो तेरा काट दिया
has not been filled up right now.
अच्छा से stop according to me the non-filling of second sentence hala non-filling of the second sentence under item number 9 ठीक अछि of part 3A by respondent or लिख दूँ or mentioning NA according to me non-filling of second sentence also by the respondent in his 3 sets of nomination paper papers that is i.e. exhibits 39 40 and 41 exhibit 39 40 all or mentioning NA in exhibit 42 is not login 42 ta exhibit login is not a defect of a substantial character which I was convinced after exercising from yes
nomination paper ta pura cover he jayega
I put it to you. I put it to you. The respondent is qualified and not disqualified.
paragraph put कर दियंतु sir
ଏଇଟା ଲାଷ୍ଟ ସପ୍ତାହ
ଏଇଟା conclude କରିବେ ତ ଆଜି?
ଆଜି conclude
ହଁ sir ମୁଁ ସେଇପାଇଁ କହୁଛି ଆଉ ଗୋଟେ separate paragraph କରିବେ ନା sub para କରିବେ?
ନାଇଁ ଆରି ଲାଷ୍ଟ
ଆଚ୍ଛା last sub para କରୁ sir.
The respondent is qualified and not disqualified under provisions of law prescribed under section 32, section 33 and section 34 of the RP Act 1951, and he shall be deemed to be duly nominated as a candidate in the election in question under the above provisions of the law.
Yes. Sir document.
The respondent is qualified and not disqualified
ଟିକେ slow ରେ ଯାଅ.
Under the provisions of law prescribed under section 32, section 33, and section 34 of the RP Act 1951, and he shall be deemed to be duly nominated as a candidate in the election in question under the above provisions of law.
ଗତକାଲି ମେଲର ଟୁ 33(1) ଟାକୁ 7ଟା ଭାଗରେ ବିଭକ୍ତ କଲେ ଏକାଥରେ ଲେଖିବା କଥା ନଟ୍ ଡିସକ୍ୱାଲିଫାଇଡ୍ ବୋଲି ତା ରହି ଯାଇଥିଲା ତେଣୁ ସବୁ ଗୁଡା
ନାଇଁ ଠିକ so sir cross examination is closed.
ନାଇଁ ଆଜି ପାଇଁ sir.
ହଁ ନାଇଁ ଆଜି ପାଇଁ so
କାଲି ରଖିବେନି ପରନକୁ ରଖିବେ ଆମର 20 ରେ କମ୍ପ୍ଲିଟ କରିବେ 20 ଭିତରେ କମ୍ପ୍ଲିଟ କରିବାର ଅଛି ମୁଁ ଆଉ ଯୋଉ ଗୁଡା ଅଛି ସେକ୍ସନ 33A ଆଉ ଅନ୍ୟ ଗୁଡାକ ରୁଟିନ ଚାପ୍ଟର ସେଇଟାକୁ କହିଦେବି ତାପରେ ସଜେସନ ଟା ଦେଇଦେବି ଆଉ ମତେ କାଲି ଯୋଉ ମୁଁ କରିବିନି ମତେ ଶୁକ୍ରବାର ଟା ଦେବେ 20 ତାରିଖ ଜାଗାରେ
20 ଯଦି ଓଭର ହେଇଯିବ
ହେଇଯିବ
ଯଦି ଇନ କେସ୍ ନହେଲେ ତାହେଲେ ଶୁକ୍ରବାର ଅଧଘଣ୍ଟା
ସଜେସନ ଅଛି ନା
appearing in the judgment process since there is no time to the further prosecution of PW3 will resume on 20th. At told the matter will be taken up at 2 p.m. Periods are remain present for the procedure for further process. ठीक है So Mr. Kanungo, so it is almost complete. Now you are required to file your memo, right? Are you closing your case? Sure.
Well, not sure. We will also check up the evidence within our DO. If by chance,
because that was the understanding that you will file a closure memo. Because once you file the closure memo, SAR has assured to give the evidence affidavit on 31st of July of the respondent, so that you will get a chance to cross-examine in the month of August.
A little correction.
Sir.
31st and 1st. ठीक है रखो.
अच्छा.
ये जो सबमिट मु करवा कथा एविडेंस ऑन एफिडेविट टा सेटा को 3 ରୁ 5 ଭିତରେ ରଖ.
First of all, sir, you finish it on 20th or maximum by 21st. Okay.
नहीं काली तो आज 18 काली 19 टा रहउनी 20 21 ଭିତରେ
Okay.